Our next speaker is Ms. Rana Arrabi, Counsellor at the Permanent Observer Mission of the State of Palestine to the United Nations here in Geneva. Ms. Arrabi regularly represents Palestine before the Human Rights Council and its mechanism, working at the intersection of international humanitarian law, human rights, and accountability, including engagement with the Commission of Inquiry and Special Procedures. Today, she will speak to us on the ongoing genocide in the occupied Palestinian territory and on the discriminatory death penalty law as an institutional mirror of systematic non-compliance and accountability failures. Ms. Arrabi?
And for inviting me to participate in this forum. And good afternoon to you all. After what Dr. Qasim has presented, I find it difficult to actually go on with what I'm planning to say because it shows it all, but I'll do what I can. I would like to begin by saying that we are not confronting a situation in which the law is unclear. We are confronting a situation in which the law has been clearly articulated, yet remain unenforced, in spite of unmistakable evidence and repeated warnings. This is the result of the persistent and structural impunity for the perpetrator and its accomplices, which has allowed grave violations of human rights and international law to continue and intensify for decades, instead of being prevented, brought to an end, or even punished. The starting point is thus not merely of a legal theory. It is the reality on the ground of the conditions of life imposed on an occupied population that has been subjected to oppression, persecution, systematic dispossession, and violence for more than 78 years. What we are witnessing is not a temporary escalation, nor a series of isolated violations. It is a well-sustained pattern of conduct implemented through various tools, including legal, military, and administrative measures, culminating in an apartheid regime, grave breaches, and other atrocity crimes, including genocide, all of which are aimed to weakening and fragmenting, destroying, and ultimately eliminating the Palestinian people as a group and to be replaced by a settler population. So to understand this, we need to look to a few indicators. For example, as Dr. Qasim has stated, in Gaza, we are witnessing a mass killing, mass injury, and the destruction to the conditions necessary for survival, including the systematic targeting of water, food, sanitation, and the healthcare system. This has meant the deliberate deprivation of food, water, and medical care, placing the population in conditions of acute famine, disease, and degradation, creating an environment in which life itself becomes unsustainable. As has been mentioned also that at least 72,000 Palestinians have been killed, including more than 21,000 children since October 2023, with more than 170,000 injured. These figures do not account for the many indirect deaths, as Dr. Qasim has already showed, nor do they capture the scale and nature of the injuries, which have left tens of thousands with life-altering disabilities, which also reflects a pattern of harm previously documented through previous aggressions towards Gaza, like the Great March of Return in 2018. And also, over 80% of all civilian infrastructure and structures, including homes, hospitals, schools, and universities, have been destroyed or severely damaged, while virtually the entire population has been forced into repeated displacement. Entire neighborhoods have been erased, whereas hundreds of families have been wiped from the civil registry. This is not incidental or collateral harm. It is the deliberate destruction of civilian life and the conditions required for a people's survival. The legal characterization of that reality has converged across multiple independent international bodies. I will start with its number of a series of provisional measures has recognized the plausible risk of genocide and the real and imminent risk of irreparable harm to the Palestinian people, and ordered legally binding provisional measures pertaining to Israel's aggression and conduct in Gaza. Later on, in March 2024, the UN Special Rapporteur on the situation of human rights in the OPT concluded that the threshold indicating Israel's commission of genocide has been met. Importantly, this assessment was reached through a cumulative legal analysis, examining not only the scale of destruction, but also the systematic targeting of civilian life, the dismantling of conditions necessary for survival, and the broader context of dehumanizing rhetoric and policies. It is this combination of acts, patterns, and intent that supports the determination that the threshold of genocide has been met. In subsequent reporting, the SR further framed the genocide in Gaza as colonial erasure and as a collective crime enabled not only by state actors, but also by private corporations, financial institutions, and academic structures that sustained and legitimize it. Additionally, the Independent International Commission of Inquiry, as Dr. Qasim already mentioned, that they found in September 2025 that Israel has committed acts of genocide in Gaza and identified 4 of the 5 genocidal acts under the Genocide Convention. When these facts are assessed under international law, the classification that emerges is no longer limited to individual violations, but it's structural. The characterization of genocide cannot be made in isolation, as noted by the UN High Commissioner in December 2023 in the commemoration of the 75th anniversary of the Genocide Convention. He stated, quote, "Genocide is never unleashed without warning. It is always the culmination of serious human rights violations, identifiable patterns of systematic discrimination, and dehumanization that have long been ignored." End of quote. Importantly, the Commission made clear that the legal framework and indicators of genocide is not confined to Gaza and may apply to the West Bank as well. As such, the West Bank cannot be separated from the picture and the framework we're discussing here. Since October 2023, more than 1,490 Palestinians have been killed in the West Bank alone, including over 237 children. In its January 2026 report, OHCHR found reasonable grounds to believe that Israel's system of separation, segregation, and subordination of Palestinians amount to apartheid, and that areas where illegal settlers reside have been effectively annexed. This is further entrenched through legislative and administrative measures adopted by the occupying power. Most recently, in February 2026, Israeli and land registration procedures were imposed in the occupied West Bank for the first time since 1967, alongside other measures like the reclassification of extensive areas to so-called state land. As confirmed by the ICJ in its advisory opinion in July 2024, Israel's continued presence in the OPT is unlawful and must be brought to an end. In other words, the legal frameworks of genocide and apartheid are not confined to territorial geographies such as Gaza and the West Bank. They must be understood as part of a continuous system targeting Palestinians as a people across the OPT through multiple unlawful acts, policies, and crimes designed to dominate, displace, and destroy. Therefore, it's against this background that the discriminatory death penalty law against Palestinian prisoners must be understood and challenged before it becomes a normalized practice. Today, more than 9,600 Palestinians are currently detained, including approximately 3,500 held without charge or trial under administrative detention, and hundreds of children. Around 4,000 Palestinians, mostly from Gaza, have been forcibly disappeared, their fate unknown, without access to legal safeguards, families, or independent monitoring. It's important to note that this escalation did not begin in October 2023. Measures targeting detainees were already being intensified prior to that date, including in publicly announced Israeli policies to further restrict food, visitation, and other basic rights. It's important to highlight that the last report by the UNSR in the OPT further links Israel's systematic torture and ill treatment, including physical and psychological abuse of Palestinians in its custody, to the broader genocidal process and the structural component of the ongoing genocide. Since October 2023, at least 90 Palestinians have died in Israeli custody. Many cases involve torture, starvation, rape, denial of medical care, and other forms of inhumane abuse. This figure is likely to be an undercount, as Palestinian prisoners and detainees have been largely isolated from the outside world, with the ICRC and lawyers prevented and denied access for nearly more than 3 years. The recent law reflects the same structure already documented: the devaluation of Palestinian life, the normalization of extreme violence, and the use of law to formalize domination, and the progressive collapse of restraint in a system that has learned there will be no meaningful consequence. What is already being carried out through unlawful killing, torture, arbitrary detention, and systematic discrimination is once again being codified through legislation. The law reintroduces the death penalty within a framework that is already structurally discriminatory. It applies to Palestinians within a military court system where conviction rates have been reported to reach 96 to 99%. Proceedings rely on secret evidence, coerced confessions, and lack fundamental guarantees of due process. This law removes safeguards, eliminates clemency, and mandates execution within a short time frame. It is embedded in a dual legal regime, one in which Palestinians are subject to military courts and proceedings, whereas Israelis, including settlers residing in the same occupied territory, are subject to a civilian system. The reintroduction of the death penalty in this context is particularly grave, not only due to its discriminatory nature, but because it runs also counter to the global movement toward abolishing the death penalty, to which the State of Palestine remains firmly committed. What this law does is to legitimize such practices through formal legal mechanisms, transforming what is unlawful into what presented now as lawful. It is in effect the legitimization of the illegitimate. The broader consequences of this law are also very clear. It reinforces and legitimizes violence against Palestinians by state actors and the settlers. It deepens impunity, and it inflicts severe and lasting fear, trauma, instability, and despair on Palestinian families and communities. Although Israeli human rights organizations have filed a petition before the Israeli High Court challenging this law, Palestinians do not view this court as an impartial body, but part of the same colonial judicial system, because this court has sanctioned, tortured, upheld inhumane practices, including the withholding of Palestinian bodies, and refused even to hear clear arguments against the so-called Basic Law, which erases the Palestinian people and considers all of historic Palestine as belonging to the Jewish people, granting exclusive rights to self-determination over our land. Even if this law or parts of it are struck down, this should not be mistaken for meaningful change. It will not alter the broader reality of widespread and systematic killing, whether in detention or in the streets. Therefore, this shows that it is a matter reflecting a broader system characterized by violence, discrimination, and the erosion of legal restraint. With all of I presented, I believe this brings us to the central question of this session, what happens when courts fail and when enforcement fails. I believe the situation in the occupied Palestinian territory provides a clear answer. The facts are extensively documented, the law is clearly established, legal determinations have been made, and yet the conduct continues. This is not a failure of the law, it is the failure of enforcement. And when enforcement fails, violations escalate, normalize, and ultimately being formalized. The death penalty law is one such moment. It is a reflection of a broader system in which violations persist in the absence of accountability. The lack of any real reaction to those violations is precisely what has enabled this moment. It has led to increasingly brazen conduct carried out in full view. However, too often, discussions of compliance are reduced to technical questions, like, for example, whether a domestic court may review a law, whether safeguards exist on paper, whether amendments may follow. But the real compliance challenge here is far deeper. It is a state acting as an occupying power. It is using legal mechanisms to intensify the prosecution of the population it occupies, while much of the international community continues to respond with timid words of concern without any real action or consequence. It is the international law is completely discarded and selectively invoked, while impunity deepens. And it is that in the absence of accountability, unlawful conduct escalates, not merely condemnation, but action. States must act consistently with their obligations under international law. They must not aid, assist, recognize, normalize, or sustain unlawful situations, as confirmed by the ICJ in its advisory opinions. They must ensure accountability, and they must act with urgency to prevent this law from becoming yet another mechanism through which Palestinian lives are placed at the mercy of a discriminatory and coercive system. At a minimum, at this moment, pressure must be exerted to at least revoke this law. We all know that this alone is not enough. What this moment reveals is the danger of always treating a new Israeli measure as an isolated incident, detached from the wider structure that produces it. So if the broader reality is still intact, the next measure will follow, and the next measure will follow. And here I would like just to mention briefly that there is a discussion on a bill to basically prosecute the forcibly disappeared population from Gaza as connected to Hamas violations, Hamas attacks, and they will be also under discussion to use the death penalty towards them without any, there's still talks about that. So it's important to look into that. So basically what I was saying that the issue is not only a discriminatory death penalty law, it is a system that makes such a law possible, thinkable, and politically viable. So for Palestinians, this is not an abstract legal debate. It is about whether law will continue to be used as a weapon against them, or whether international law will finally be applied with seriousness, consistency, and consequence. With that, I give back the floor to you. Thank you very much.
Thank you very much.